Good evening, everyone. Can everyone hear me okay? Perfect. Tonight we are going to be talking about the rental reform and how we can navigate it. My name's Che and I'll be hosting this evening. Before we start, I have to let you guys know where the fire exits and toilets are. So in classical air host style, the exits are there, and there. And the ladies' bathrooms are over there and the men's are over there. I also want to let you guys know that tonight is going to be recorded. You'll all be sent a copy and we may be using some stuff for social media. Tonight we have a panel of 3 professional speakers. On my left here is Susie Croller. She's very well known and experienced in the region of lettings. She is also the CEO of the Guild of Letting and Management. In the middle is our very own Tony Uris. He's been in lettings for over 40 years. And this week will be Anthony Webb's 26th birthday. And on the far right, we have Jack Marku. He is a partner at GC Accountants, and he's going to be telling you guys how we can navigate the upcoming of making tax digital, which is coming into effect in April. Following these presentations, I'll be asking the speakers some questions that have been laid out by you guys. We'll also be giving you a chance to speak yourselves. I'll have someone coming around with a mic. And at the end, if I can ask you guys to move towards the back where we'll have refreshments and sandwiches. Without further ado, Susie.
Thank you. I'm Italian. I don't need a mic. So, good evening. Thank you, Shay, for that lovely introduction, and welcome to everyone to this very, very crucial event. This is the second event that I've actually been present at. The first time I've been physically present. The last time my presentation was actually pre-recorded. So firstly, thank you to Anthony Webb for organising this. It takes a huge amount of work. And around you, you will have colleagues who have their Anthony Webb badge on. And if you do have any questions about the services and what Anthony Webb can do for you, please do make sure that you check in with them. Now, as Shay said, my role this evening is as a speaker. I'm spending actually a lot of time talking, which is what I do for a living, and training specifically on the Renters' Rights Act, which you should be able to see in front of you on the screen. Now, I don't have a clicker, so if you hear me say next slide, that means the next slide will be coming up, and I've got somebody helping me this evening. So can we have the next slide, please? You, unless you've been somewhere very, very far away from the UK, you will know that we have very significant change happening within the private rented sector. So this evening, I'm not talking to you about social housing. I'm talking to you specifically about legislative change, the most significant in the last 30 years. Okay, so that's a whole generation. So one of the reasons that you're all here is to find out what's going on, get an overview, hopefully feel comfortable about what you need to do in the next just under 12 weeks. Okay, so that's what we're going to focus on. You can see some of the elements, our objectives for this evening, and as Shay said, that you will have access to this recording. So that's very, very important for you to look back and think about some of the things that we've discussed this evening. Next slide, please. Okay, so I'm not sure how many of you have paid really very detailed attention to what's on the screen. Prior to the Renters' Rights Act, we had the Renters' Reform Bill, which was brought in by the previous government, and there was talk about that as far back as 2019. So this idea of reform, housing reform, especially for the private rented sector and for private landlords, has been discussed for a while. But some of the things I want you to think about that you can actually see on screen, approximately 226 pages of legislation. Not the biggest piece of legislation there is, but very significant. The detail, some of it is very complicated, And obviously, if you are a landlord, you may or may not have read that information. The other point on screen are the guides. Now, to date, the government has published 24 guides. Some more are coming online in March, and that's very important for you. The point I want to make here is that if you are a landlord, what I call a DIY landlord, you need to be as engaged as the managed landlords around you, those that use agents. So the legislation is written primarily for you. It's not written for letting agents. The letting agents, Anthony Webb, for example, are the conduit for you. They're making things happen. They're making sure that you stay compliant. So I just want to give you an idea of what we're dealing with on a daily basis. Next slide. So the next two slides will show you the government roadmap. Now, most of this, as you can see, the legislation, Royal Assent, was introduced in October 25, and we've moved quite quickly since then. So, for example, the guides that have been published are online. They're being updated either every week or every few weeks. So civil servants are making changes depending on the feedback that they're getting from people like you, from people like Anthony's team, from people like me. Okay, so this is very, very important for you because they want this to work regardless of what the opinion in relation to the legislation actually is. If we move right down to the bottom, you can see that we've actually covered all of that. And if I can have a next slide. This is where we are. And this is the key date up here, 1st of May. That's why I keep counting down the weeks. So as from Monday, and that was obviously the beginning of February, we had 12 weeks. Next Monday it will be 11, okay, to get ready for what will happen on the 1st of May. Now, that's nothing to do with scaremongering, worrying people. You need to make sure that you're prepared, okay? The agents that we work with, and we work predominantly with agents, if I give you an example, Anthony Webb have probably attended 5, 6 training courses, full days, plus webinars, to make sure that they understand what's happening in the lead up to the 30th of April, okay, when things change automatically the next day. So that's our focus, and that's what we're going to be focusing on this evening. Next slide, please. Okay, so I want to work backwards. I have 2 slides for you, and I want you to think about where you sit in this contractual relationship, landlord-tenant. But away from that, you have enforcement. Now, what the government decided, and this caught a lot of landlords by surprise and some letting agents who really aren't that switched on, was the fact that the government has given every single local authority in England new enforcement powers. And they are, I'm going to split them up into 2 elements. The first, and these started on the 27th of December, which is a very bizarre date because it was slap bang in the middle of a festive period, so it's a little bit strange. The first is that the local authority has the right to ask for information. Now, they can ask for that information by serving a notice. So they can write to any one of you, any letting agent in the whole of England, depending on the kind of information that they require, and ask for specifics about a property. And the landlord or the letting agent has to legally comply. And it could be in relation to health and safety, it could be in relation to a licensing issue, but the landlord and or the letting agent must comply with that notice. That would be the formal notice, and you'll be given a time frame within which to comply. The second is a little bit more concerning, and it's known as a non-routine inspection. Now, non-routine inspection means that the local authority can attend a rented property and or a letting agency without notice, within work hours, and request information about a property. And people say, why the non-routine inspection? That is because they feel that there is a very serious breach of particular housing legislation. So those two things are very, very new. Now, we give legal advice to agents. We work predominantly with agents, and we can see this information starting to filter through. So it's very, very important, and this is what I say to agents and I say it to landlords, is you look at your portfolio and you see if there are any issues that could raise concern. How would the local authority know that there's a serious breach? They could have been tipped off by the tenant, neighbours, they could have seen that there's overcrowding, they know that there's some issue. They don't want to tip the landlord off, so they will just appear. So I want you to be aware of that, and you are in a borough, unfortunately or fortunately, where they have a really good understanding of what this is. Okay, so they are the new enforcement powers. If I can have the next slide, you will see why my very last slide is so important, and I'm not going to tell you what it is. These are the penalties for non-compliance. Now, with my team, we run a legal advice line. We deal with what I call the sticky end of the lollipop, problems, finding solutions, issues. Our premise is to make sure that our clients, letting agents, are very well protected. If you use a letting agent, and I'm not going to ask for any show of hands, if you use a letting agent either to let a property, to collect rent, or to manage a property, they are your safety net. They are your safety net against penalties like this. And the penalties, these particular ones, and I've put them in red for a reason, will start on the 1st of May 2026. So any penalties at the moment will sit under different pieces of legislation. Okay, so that's really important. And the penalties could be an initial penalty of, let's say, £500, but then subsequent penalties of up to 40,000. Okay, so it's really, really important that you have a really good understanding. I specialise in landlord and tenant law. I'm all about making sure that the client doesn't get caught out. That's what you need to be thinking about your portfolio. Now, on top of that, if you imagined this was an enforcement cake, you've got some icing and on top is a cherry. That cherry is a rent repayment order. Rent repayment orders are tenant incentivised penalties. These penalties encourage tenants to report landlords to the first tier tribunal to obtain the rent that they have paid as a repayment back to them. Currently, up to and including the 30th of April, a rent repayment order is a maximum of 12 months, and the tenant has 12 months to apply, even if they've left the property. From the 1st of May, that 12 months goes up to 24. And you can see that I've done a calculation here, or perhaps over there, or perhaps I haven't, but I'll give you an example. If you imagine your highest rent, okay, I want everybody to think about that. You multiply it by 24, and that should give you a figure. That is the potential rent repayment order that you could be faced to pay back to a tenant. Now, yesterday I did a training course. I asked everybody to do that exercise. And one of our clients, their highest rent was X, multiplied by 24, 138,000. That's not good. That's not good for landlords. So you really need to be thinking about how you make sure that you do not get caught on these things. And I've dealt with these since 2018. For the tenant, especially with no win, no fee lawyers, organisations that support tenants, point them in the direction of the first tier tribunal. I'm calling it an easy win, and it really is. Okay, so for me, if you work with good agents, they should be able to protect you from this. Okay, you need to listen about thinking about their fee versus a rent repayment order. For me is a bit of a no-brainer. Okay, and that is really, really important. Okay, so that's the horrible stuff. We'll move on to the nice stuff now. So everything in pink relates to paperwork. I'm a visual learner. I like to break the legislation down. I colour code everything so that myself and my team know what we're working on, but our clients use these kinds of infographics as well. So from the 1st of May, all of that will change. At the very top, you can see no more fixed term tenancies. So you have a start date, but no end date. Okay, everything becomes periodic on the 1st of May. Added to that, no more Section 21. This was the big headline in 2019. And a lot of landlords exited 6 years ago thinking the legislation would happen straight away. It doesn't work like that. And it's very disappointing that the press misled so many landlords. Okay, so that's really, really important. What it does mean, it means that the Section 21 won't be available, but there is another alternative, okay, and that's Section 8. And if you're getting your information from either your legal team, your solicitors, from your letting agent, you will understand that it's not as bad as the press and everybody else that's scaremongering is making it out to be. It's not as bad. And then right at the very bottom, I've mentioned Section 8, the new version. And I know I can preempt the questions. I can preempt, can I sell my property? Can I move back in? Am I going to be stuck with a tenant? The answer to that question is no, you're not going to be. You do have options, okay? So you need to get good advice, good support. Next slide. Next slide is a different colour, well, a few colours. Right at the very top, we have everything in green is about rent. Okay, so the process for landlords will change in terms of increasing rent. There's been a lot of discussion about this, predominantly the involvement of the first tier tribunal and the fact that the tenant will have the right to challenge a rent increase. But they can do that now. If they read the Section 13, page 2 and 3, they can see where the notes are, they can see where the guidance is. So none of this is new, but you're going to have to prepare yourselves in advance in a really business-like manner, okay? Not increasing rent for 5 years is not a good idea. That's not a good idea. That's not a good business decision. So you need to think about how you calculate your rent increases, where you get your information from, what information you give to the tenants. That's really important. Okay, so that's the key part about rent. In the middle, rental bidding, no pitching one tenant against another. Saying to a tenant, if you offer more than George, then I'll let you have the property. That is going to become illegal. And also, landlords will only be able to accept the advertised rent. And then I'll talk to you a bit later on about advance rent. In the middle, I call this, can I have a llama and a few pigs, basically. There's a lot of discussion about pets, you know, this thing that this is a blanket ban. It actually isn't. You go through a process, the tenant goes through a process, and you make a decision, okay? But the tenant has to follow that process. So that's very important as well. And right at the bottom, some new terminology, rental discrimination, which has been around a while. That's not new, it's probably pre-pandemic, where landlords or agents would openly say to someone, we don't take people in receipt of benefits, we don't accept people who have children, we don't accept people of a particular nationality. That's not an option. In print, saying it, understandably, you might think it's a landlord's choice, but you have to take each case on merit. So that is very, very key. Okay, next slide. I think we have some more colour. Oh no, we don't. So this is brand new. 2 new legal duties for landlords. 2 weeks ago, on a Monday, the government issued what is known as a statutory instrument. And the statutory instrument explained 2 new legal duties for you. The first is the information sheet. And the second, I'm just going to abbreviate it to the written statement, okay? So these 2 legal duties have to happen by law. The information sheet applies to all your existing tenants and all your existing guarantors. So that's a really important document. And then the written statement is a new layer within your lettings process for your new tenants. And there is an order within which you'd have to issue the written statement. Okay, so if we can have the next slide. So the information sheet, I'm not giving you a huge amount of information because that egg timer applies to me as well. I explained that I'm Italian, and somebody said to me this evening, how long do you need for this presentation? And I said at least 3 days. I'm not going to have 3 days, but I really want you to focus on the fact that right at the very top, if you are a let-only landlord, i.e. you manage your own stock, but you use an agent, this applies to you. If you use an agent for rent collection, this applies to you. And if you are a managed landlord, i.e. you use a managing agent, as you might do with Anthony Webb, then you're fortunate because they're going to be doing this work for you. So it's really, really important that you understand that this is a new legal duty and it has to be done. Now, the problem with this one, and I'm not sure why the government, civil servants, decided to pick May. May is not a good month. Okay, the reason May is not a good month, 2 bank holidays, quite a few weekends, and the 30th of May is a Saturday and the 31st is a Sunday. So whilst people are thinking, I've got 31 days, that is reduced right down. And our clients are on top of this. Okay, now, Anthony mentioned to me earlier, do you think the government are going to allow the information sheet to be issued earlier, i.e. when they release the information sheet? Maybe in March or April, it depends on the government. But you need to take legal advice if you think you can do that. Okay, because what happens is when you serve this information sheet, you've automatically switched from assured or assured short hold to assured periodic, which means you won't be able to serve notices that exist now. Okay, so that's very important. If we can have a next slide, I think this is about the written statement. The written statement, I've put compliance. Now, everybody keeps saying to me, well, in fact, somebody sent me a written statement today and I smiled because I thought, oh my God, that's clever because it actually hasn't been published yet. And they'd written their own, which was lovely, it was great. But the information sheet and the written statement are going to be 2 statutory documents issued by the government with placeholders in them, and you have to fill them in. Okay, and I do stress this in advance because I've been to court a lot of times, a lot, and you don't want to make mistakes on documents. Okay, so you need to be really certain that if you're going to do this yourself, you are really sure that you've understood what you need to put onto the information sheet, and more so this one. This is for all your new tenancies. So what will happen is, when you've got a new tenancy, in between the offer stage and the tenant signing the contract, this is issued first. So it's written statement first, tenant signs the terms, then they sign the contract. Okay, so that's quite important in terms of order. We've never done that before. They introduced this in 2023 under Rent Smart Wales. So if anybody's got properties in Wales, they'll understand what this is. And basically, it's telling the tenant, these are the terms of the tenancy. Are you happy? Is this what we discussed? Sign here. And the likelihood is they'll read this, but not the contract. That's my view. So as much as it's an added burden, and our clients are looking at this already, okay, because they have software, they have electronic signature platforms, so they can issue this paperwork knowing what they need to do in advance. You need to do the same. That's really, really important. So next slide. Section 21. I'm not going to spend a lot of time on this because you will have the power, the ability, the choice of serving a Section 21 for vacant possession. Can we not call this an eviction notice? It never has been, it never will be, even if it was still in place. So if you want the property back, you've not given a reason, you can serve your notice up to and including the 30th of April 2026. But be careful that there are no mistakes on it. What the majority of our clients are doing, and probably Anthony Webb as well, is they're looking at restricting service of notice within their agency, probably up to the last week of April. Because if you make a mistake, you can't then undo that mistake and reserve. Okay, so you really need to take legal advice in that last month of 2026, being April 2026. Okay, because this switches over on the 1st of May, there will be no more Section 21. If you serve notice before the 1st of May, and that notice expires after the 1st of May, you need to make a decision as to whether you're going to start court proceedings if the tenant does not vacate. So if the tenant doesn't leave, you'll get your legal advice, but you have until the 31st of July 2026 to issue court papers to the court. Okay, and we all know that the cut-off times in the court and when we serve notice is 4:30. So again, I would kind of preempt that, and I'd be organising myself if I were to go to court to make sure that it is nowhere near the 31st of July. Okay, because I could miss things, make mistakes, and again, you always take legal advice. Okay, Section 8. Section 8. Now, I'll give you an example. Yesterday, and probably for the last 2 years, 2.5 years, we spent at least 2 hours on a Section 8. Section 8 is a document that has been around since 1977 under the Rent Act. It's been amended a few times, and this is the biggest amendment. Okay, so this will be the only notice that you will be able to serve to get your property back. But you must have a reason. And the other key point is you've got to have evidence. And my example, and this has kind of become a bit of a famous example, not worldwide because I'm not that famous, but within what I do, I say the tenant has a dog. And my clients look at me and I say, would you serve a notice for me? And they say, okay then, but they don't ask me any questions about the dog. They don't say, how did you know the tenant's got a dog? Is there a restriction in the head lease? Did you give consent? What does it say in the tenancy agreement? What has this dog been doing? So you need a lot of information about the dog. Okay, and that's just a very small example of how you need to prepare yourselves if you were to serve notice, either for a breach, because Section 8 has grounds for breach of contract, the biggest being and the most significant being rent arrears, and then a reason, for example, you want to move back into the property, or a family member might do, or you want to sell. Okay, so navigate this really well with those of you that have solicitors on tap, those of you that use a legal team, those of you that use agents. The agents have been going through these grounds probably since they were published last year, okay? It's grounds 1 and 2 that you need to think about, grounds 1 and 1A that you need to think about the most carefully, because they have restrictions against them. And this is what's been causing a frenzy. If you don't read the detail, you don't know that the restrictions apply to new tenancies only. Okay, so that's really, really important for a landlord to know. It's not, what about my tenant who's been living there 5 years? That's completely different. So you've got to understand timing, the reason, and you get support, and there'll be a lot of information online. Okay, the other thing that I want to say, and this is just generic, this is not just about the Renters' Rights Act, is find your sources through .gov.uk. I had somebody send me information yesterday and they said to me, Susie, what you've said is wrong. And I said, that's fine. I don't mind being challenged. I'm really old. I can take it. I'm not bothered. And they sent me information from ChatGPT based on information in Northern Ireland. That's not helpful. Okay, how do I know that? Because the website ended in an NI. I've had information sent to me from Canada, New Zealand, Australia. Stick to the UK. .gov.uk is your point of reference, and if you really get stuck, then you've got people in this room who have hundreds of years of experience and have been through this for the last 3 years. Okay, so understand the purpose of Section 8. Next slide, please. Okay, rent increases. This is, so if you were all pigeons, that's not offensive. Well, it might be. So apologies. I think Tony won't ask me back. And I had a cat. This is where I throw my cat. I love cats, so I'd never do that. Cat amongst the pigeons, okay? This has caused a lot of problems. So Section 13 has existed for a long time. It's not a new document. But the only way that you'll be able to increase rent from the 1st of May is using Section 13 notice, which will also be known as a Form 4A. Okay, all these documents you can find online with guidance and so on. Tenant will have 2 months' notice instead of 1, and the notice must be served in line with an anniversary date and or a rent date. And I say that because some landlords allow the rent date to be changed. Okay, so that's really important to bear in mind. Now, one of the things that the government and then the House of Lords kind of batted backwards and forwards between House of Commons, House of Lords, is what level are you permitted to increase rent at? Because there was a lot of discussion about rent control and all sorts of nonsense. No RPI, no percentages, no CPI, market rent. Okay, so you need to get your data, it needs to be accurate, you need to pull together information, and they're known as comparables. Okay, now I'm not a specialist in that. That's not what I do. The people around me in this room who work with Anthony Webb, that's what they do. They understand comparables, how to value, how to get the right yields, percentages, all of that kind of thing. And they will pull together the information. They'll have a discussion with the tenant. If the tenant has a problem with it, then they'll say to the tenant, you can look at the same information that we're looking at. This is what your market rent is pitched at. So it's really important that you understand that process. And that review, known as a rent review for the rent increase, will only take place annually, no more. Okay, so that's how it's going to work. And it's really important, and I say this with the greatest of respect to all landlords in England, because I know a lot of landlords, they kind of suspended a rent increase for lots of different reasons. You need to think really carefully. You need to think, if I haven't increased the rent for 5 years, how am I going to get my rent up to market rent? And it might be a problem. Now, if you have a discussion with the tenant in advance, before you serve your Section 13, that is the best way to do it. Because otherwise, they're going to end up going to the first tier tribunal. The problem with the first tier tribunal, and you might have read this in the press, and you might have heard lots of different things about the FTT, as we call it, and it's the property chamber, not just any kind of first tier tribunal, is that they have a backlog. They have a backlog. They don't have enough judges. They sit under the Ministry of Justice. I think at last count 2 years ago, just before the election, it was calculated they need, within England and Wales, 1,000 judges. So that should tell you something. Any delay in getting a response, if the tenant goes to first-tier tribunal, doesn't mean that if the decision in terms of what you want as a rent increase is agreed by the first-tier tribunal and it takes 6 months for them to agree that with you, it won't be backdated. And that is the biggest problem. So you need to enter into discussion. You need to get advice. You need to understand comparables and your market, okay? And we've delivered training up and down the country, and the landlords are feeling the same thing. And they're looking to their agents to say, you need to help me with this because I don't want to go to first-tier tribunal. Okay, you're going to get that tenant who you know will go to first-tier tribunal. Okay, so even before you go into the hearing, you can have a discussion beforehand. And I've done that. I'm a qualified mediator. I prefer to mediate rather than go to court and to first tier tribunal, because you can always find a solution. Okay, so bear that in mind. Okay, next slide. Okay, something else about rent. And there are 3 things on here. Advance rent. Now, some of you may have tenants who don't pass affordability. Okay, so if they are being referenced through a referencing company, the referencing company will either recommend rent in advance for the term, let's say 12 months, and or a guarantor. Okay, so that is to minimize the risk because the tenant hasn't passed referencing. Now, something that's really, really important, I've mentioned that we're going to have assured periodic tenancies. In order for you to take rent in advance, 1 month only, 1 month only from the 1st of May, the contract must be signed first by you and your tenant. And then they pay money, 1 month, and then you give them keys. It has to be in that order. Now, if the tenant, only the tenant, not you, the tenant says, I would like to pay rent in advance. So I've just sold my house. I'm looking for some stability. I don't want to put money in the bank, which is a possibility. For lots of different reasons, I'd rather pay 12 months up front. That needs to come from them, and that term would be put into the contract. So it then becomes a contractual term. But they wouldn't be able to pay that further 11 months until they've moved into the property. Okay, so again, when you're putting your paperwork together, when you're having discussions with the tenant, you must not push them towards more than 1 month's rent in advance. That needs to come from them. The other thing I've mentioned already, rental bidding is not going to be tolerated. Now, I've listened to lots of discussions over the last 18 months, 2 years, and they've been discussions in the House of Commons, House of Lords, and they think that all of you, well, not all of you, 2.7 million landlords encourage tenants to bid against one another, and all the agents as well in England. That's not the case. It's supply, demand, lack of supply, people who really need to move relatively quickly, lots of different reasons why tenants offer more. Okay, so please bear in mind that the local authority will be looking at advertised rents and how that works. Okay, so we need to make sure that we're very clear about the rent that we advertise and the offers that we do accept. Next slide. This is my favourite. Can you rent to me with all these animals, please? And I'm a really good tenant and they're all very well behaved. Probably you're thinking, absolutely not, Susie, that's never going to happen. But I just want you to be aware that this was another headline that was picked up and run away with by lots of different organisations and lots of different press. Landlords banned from refusing pets. Not true, not true. You have to go through a process, okay? And one of the things that we've done for all our clients, and Anthony Webb obviously worked very closely with us, is we've put together a pet profile. You need to gather information to be able to make an informed decision. And most of you will be sitting there saying, I'm never doing that. I know that I'm never going to accept pets. But you've got to go through the process by law. You'll have a 28-day window to decide, which is quite a long time, unless you're dealing with freeholders or block managers who take quite a long time to come back to you. And then you can give them your decision. If your decision is yes, then you put together a whole raft of clauses. You can't take high deposit. You can say to them, do you have insurance for pet damage? And there were some really good products out there that the government then kind of changed their mind about asking you to ask tenants for pet insurance. That got scrapped. So if the tenant is a responsible pet owner, none of this is going to be a problem. Okay, so that's really important. The part that worries landlords is no, I'm not giving you consent. And you'll have to put that in writing. and you'll have to explain why. And on the next slide, I think I should have another slide. This is even more favourite. Can you rent to me with all of those? And you'll be thinking, no. You've got to look at the type of pet. You've got to look at suitability, animal welfare. You've got to think about, many of you may be leaseholders. You've got to look at your head lease. Are there restrictive covenants in place? Is it in writing? Is the head lease silent on pets? So you have to go to the freeholder, superior landlord, and ask the question. But these all come from the legislation. So there are reasons. People keep talking to me about allergies. How do I prove an allergy? Well, I'm not medic, so I can't help you with that one. But I can tell you, and somebody on training made a really, really good point yesterday. They said to me, look, Susie, all of this will go to case law. And so that means it will be tested in the courts. And over the next 3 years, it will. And the government will then review, think, should we change this? And that's normally the case, okay? But I do want you to remember that if the tenant doesn't give you the right information, then you can't make a decision, and therefore your answer should be no, okay? So that is really, really important. So think carefully, and these sections within the legislation are really quite straightforward to follow, okay? So that's our cuddly friends and my llama, who nobody will let me have. Discrimination. I come from an immigrant background. This is not something that sits really well with me. Maybe a lot of people have the same experiences as, I'm a second generation Italian. Parents here 65 years. Everybody's probably seen discrimination of some sort. You've got to take each case on merit. I've seen tenants who have £200,000 in the bank. They've proven that they have that money. They drive a Ferrari. They have got great shoes, great job, the worst tenant in the world. I've experienced tenants who are in receipt of benefits. They love their home, they look after it, and genuinely are very grateful. Now, I know that landlords are concerned for lots of different reasons, and namely maybe the system of the way that benefits are calculated, the way that benefits can change, the way that benefits can be stopped, clawback, fraud, all sorts of things. But you need to take your advice very carefully, and you need to look at this very, very carefully. So the two key things under rental discrimination are not to discriminate against anybody in receipt of any benefit, known in my generation as DSS, known now as DWP, and that's any benefit, not just housing. And then the other point is the fact that your applicants may have children, and you may think, oh no, I'm not going to take anybody who's got kids under the age of 10, but you need to factor in lots of different details. Is the property suitable? Is there a health and safety issue? Can you make reasonable adjustments? So there may be reasons where you say no that are legitimate. And again, that will be tested in the future. Okay, so that is very, very important. I think we have a database. So generally, on a training session, we normally get to this stage about an hour after lunch when everybody's feeling kind of relaxed and thinking, I just want to go home now. But agents are really interested in this, and I sit within a committee that has lots of other committees where we meet the civil servants who are in charge of this. And something they released yesterday is the second phase. They're going to the second phase of testing the database. Now, this is not a license. I really want to stress that. It's not going to replace selective licensing. It will not. The government have said no. I don't know if the previous government would have said yes, but the current one have said no. And basically what this means is that every single landlord in this room and every single landlord in England will be registered on a central database. I just want to make it clear that all your data will not be in the public domain. That's really important. Only selective bits of information about the property being compliant, just like an HMO license, Okay, so if I'm doing a search and I'm having a chat with a client and I want to see if the property's got an HMO license, I'll go onto a register within the local authority. This will be a national register. And basically, all your properties will have an individual, unique property reference number, known as a UPRN, that identifies you and the property needs to be compliant. Okay, so who will have access? Tenants will be able to see if the property is compliant. I don't want to hide anything from you. HMRC, local authorities. Okay, so if you think I'm not going on to this, you are very wrong. You are very wrong. Okay, so our clients are already prepping their clients. So for the managed properties and also for the let only at the beginning, it's great to have an agent because they're doing all the auditing. They're making sure that you don't get caught out, you don't get fined. Every single bit of information that goes onto this database will have to be up to date, accurate, and in date. Okay, so that's why the government is asking for landlords, not so that they can spy on you. And I'm going to send this in, I think I've sent this information out in our newsletter yesterday or this morning, and Anthony Webb can send it out to you. I, as a landlord, have a vested interest to see what I'm going to have to do, and you can feed in information. And it's not just for the landlords who've got more than one property. You know, our biggest client has got 30,000 properties managed. Our biggest landlord probably has, I don't know, £500,000 worth of property. Okay, that's a lot, but some of you may think that's not. But you've got to think carefully about your business, and this is also to protect you. Okay, so that's really, really important. Now, I just want to give you a date. Sorry, can I just go back a slide, just very quickly? This is going to be launched in the Midlands at the end of 2026. Okay, so they'll pilot this in the Midlands, see how it works, and then roll it out to the rest of England. So if there's anything they need to tweak. So that's in 2027, so that will be phase 2. If we can just move on to the next slide. This is the information that the civil servants gave us. So we didn't write this. You've got information here all about you. I just want to really stress none of this will go into public domain. This is the same as an HMO license or a selective license or an additional license. So that will not be in the public domain. Information, maybe some of the information in the middle will be, does the property have gas? Is there a valid gas safety? EICR, EPC, and so on. And then right at the bottom, the last column near Tony, is information about licensing. So this is all about compliance. Now, you may be cynical, some respects I am, but I'm all about a good industry, really great landlords. Without landlords and without tenants, I wouldn't have a job. Anthony Webb wouldn't have an agency. There would be no need. But this is about compliance and making sure that the demographic that give you a bad name, and I'm talking about really bad landlords, are eliminated from the market to make it easier. Because we see this every single day. We don't work with bad agents because they wouldn't bother coming on training and spending, the money that they spend and the investment. They wouldn't waste their time. You are good landlords because you're here. Because if you weren't here, you'd just be thinking, that's fine, I'm not worried. Okay, you should be thinking about your business. Next slide, I think, is Landlord Ombudsman. Landlord Ombudsman service, I'm not going to touch on too much because the key date for you there is also within phase 2 and it's 2028. They have identified and decided, they may change their mind, on the Ombudsman. And I think this is about the type of landlord that manages their own property, that the tenant contacts over and over and over again, and the landlord never replies. The landlord doesn't care that the heating doesn't work, that there's no hot water, that the fridge hasn't functioned for the last 6 months, that the oven door has fallen off. It's that kind of landlord. Okay, so Landlord Ombudsman is going to sit in line, but not totally, with the ombudsman that Anthony Webb belongs to, and also property redress scheme for agents. So we're used to this, we're used to complaints mechanisms. So I think that that's what this is about. And again, I think this is about a demographic of landlords that really just does not care. And, you know, I come across, fortunately, I don't have to work with people like that, and I know that Anthony Webb doesn't either, and majority of our clients don't, but that's what I think it is. Okay, I think I have 2 more slides. Decent home standard. Somebody said to me the other day, Susie, you're really old, and when this comes in, you're going to be even older. 2035. I know. This doesn't mean that you don't have standards. The standards are already there, and they sit under the Housing Health and Safety Rating System, which local authorities have been using since 2006. I'm a really big fan. I like the structure. I know what Category 1 hazards are. I know where to look for risk. So do Anthony Webb. That's how it works. But this is going to come into force much later on, okay? So it doesn't mean that you won't be penalised for disrepair, because you will. I think AWAB's law is next. We have just some information about AWAB's law now. I'm not going to go into too much detail because I don't think it's respectful, but you can search this online. AWAB's law was introduced under social housing under the previous Secretary of State, Michael Gove, who dealt with the situation, and he felt that it was really, really important to bring this in. This has already been introduced into social housing, and it was introduced on the 27th of October. There will be a consultation for this, and I think the consultation will probably take place after May, to kind of give everybody a little bit of time, maybe May, June. Maybe they might even skip the summer and go into the autumn. But this is really important for you to be aware of. Can I stress, even though the premise and the origins of this are about mould and damp, this relates to all Category 1 hazards. Okay, so there will be time frames within which landlords need to react to reports of repair, especially Cat 1s. Now, our clients look at this and they say, bizarre, we work quicker than this. Okay, it'd have to be something really, really very unusual for them to deal with, not in a realistic time frame. Okay, so I would keep my eye on this one, and there's lots of information out there, and you can look at the guidance that the local authorities have to adhere to. And it was really interesting, one of my colleagues gave me a letter that was given to one of her friends, and on the second page it was from the local authority who'd done some work on a property, and it referred to AWAB's law already. Okay, so look at the guidance. And I think this is it. Preparedness is key. If you feel stressed by this, as I said, I'm not here to sell anything. I'm not here to pitch anything. I'm here to talk to you about your obligations as a landlord, your responsibilities, which are statutory. Everything we've talked about is statutory. The legislation has come into play, but the first phase starts on the 1st of May and you need to be ready. So preparedness is not a made-up word, as people keep telling me. It is really important that you're ready. You need an action plan in place. Okay, we work on action plans. I'm a very practical thinker. I like solutions, and that's the way we work with our agents. So you need to think about your action plan. You need to make sure that you've got your documents ready. So you're thinking about the paperwork that I talked about right at the very beginning in pink, processes, and then events like this. Events like this do not happen regularly. This is so important for you. And I'm really, really pleased for Anthony Webb to see such a turnout, especially since it's raining. And I don't know what's on TV or Netflix, but you could have been indoors. That might have been more relaxing. Really very, very important. Do not get left behind. Do not get left behind. okay? And I think I have one final slide. There you go, ducks. So I do like my ducks. I'm famous for my ducks. Rightmove, I did some work for Rightmove and actually had chocolate ducks made for me and gave them out to everyone. We don't have any chocolate ducks, but seriously, I think we have better things. Seriously, you need to be ready, okay? And that's me.
Thank you, Susie. That was very, very informative. A lot of stuff to digest tonight. I hope you guys are staying focused. The next speaker of tonight will be Tony Uris, and he will be telling you how Anthony Webb can help you stay compliant. Round of applause, please.
Good evening, everyone. Can everyone hear me at the back? Yeah, sounds like it. My name is Tony, and I've been in the lettings industry for 45 years. I started going out with my dad, who's sitting at the front here, to his rental properties on a Sunday afternoon to collect rent when I was 8 or 9, through to opening up my own agency, Anthony Webb, 26 years ago, this week on Saturday. I'm not just an estate agent, I'm also a landlord. In my many years in the industry, I have probably come across every kind of problem you can think of, which have added to my experience and knowledge. Tonight's event is fully booked. The majority of you in this room are landlords, but we all have something else in common, as Susie mentioned earlier. The fact that you've taken the time to be here shows that you're good landlords. You care about your properties, and you want to stay on the correct side of the law, which making your investments compliant. We all know the real reason these regulations are changing. It's not because of us, the good landlords, it's because of the people that are not here tonight, the minority of bad landlords, the ones we don't deal with. These are the landlords that evict tenants because the tenant complains about repairs that the landlord refuses to do, the landlords that overcrowd properties to get more money, the landlords that get their properties checked that don't get their properties checked as they fail gas and electric checks. These landlords are giving us all a bad name. The Renters' Rights Act is one of the biggest shifts we've seen in the lettings industry in decades. Tonight isn't about panic, it's about being prepared. The first stage of the Renters' Rights Act is coming into force on the 1st of May this year. You have already heard from Susie today about the changes ahead. The main thing to take on board is that you, as landlords, make sure that you and your properties are You and your properties are compliant. This involves detailed procedure, the ability to act on problems quickly and efficiently, and most importantly, making sure you have the time to deal with your responsibilities. Slide 3. Finding a tenant is not the same as finding the right tenant. It starts with the initial inquiry. As agents, we ask the right questions to make sure all the viewers meet the required criteria. We then meet the tenants at the property, the ones that turn up, and again ask the right questions to make sure that these potential tenants meet the requirements. When they express interest, we ask to see lots of documents to back up what they've told us. Only once we have checked these documents do we approach the landlord with an offer. And once you agree, we then proceed with the professional referencing checks. Our referencing company will do a thorough check of potential tenants' documents. They will use AI technology to check if all the documents are real or fake. Just look at how easy it is to make a fake bank statement online. Scary, isn't it? looks real. Scary what people can do. That's why we use the best referencing company for our checks. There's lots of rubbish out there. We use the best one. Because of this strict procedure, our landlords experience fewer problems down the line. Some landlords try to save on an agency fee by finding tenants themselves and doing their own tenancy agreements. If you try to do things yourself, are you 100% confident that you are following the correct procedure? There are many areas that can trip you up. Just look at some of the things you have to do. If you make any mistakes, or even if you do everything correct, but in the wrong order, then that could be enough to stop a judge awarding you back possession of your property if you had to go to court. For example, we recently took over managing a property for someone that came to our last landlord event last year. On the day the tenants moved in, the landlord gave them the tenancy agreement and all the correct safety certificates together. And he asked them to sign everything. Sounds good. Sounds normal, doesn't it? A couple of years later, he asked the tenant to leave as he wanted to sell the property. He didn't want to leave, the tenant didn't want to leave, and the case went to court. The judge first asked to see proof that the tenant had all the safety certificates before signing the tenancy agreement. There was no proof. They were given by hand all at the same time. That was enough to throw the case out. As you can see, the landlord was a good landlord as he did everything, but a simple procedure made him non-compliant. There are lots of these trip hazards in lettings law. We know these. We're trained upon how to deal with them. At Anthony Webb, we run a tight ship. My staff, who you see around here today, are regularly trained, mainly by Susie, and fully up to date on lettings legislation, and are qualified to ensure nothing slips through the net. In today's lettings market, even a small oversight can become a big problem. Compliance has become a big part of being a landlord for many years, but never more so once the new Act comes into force in May. Your properties will have to be constantly maintained, you will need to have the correct safety certificates, and you need to make sure that there are no gaps in between these certificates, and that you have proof that you have given them to your tenants. Just handing them over or sending an email is not good enough. Nowadays, most councils require you to have a licence. Lately, Enfield Council, the one we're in here, have been doing random audits. They started all of a sudden last year, and make sure that you're doing things correctly. How many of you create reports every 6 months, condition reports about your property every 6 months? It's a condition of your licence. Did you know, do you check your smoke alarms on the same day the tenants move in? It's law. How do you document all this? Compliance is making sure you do things correctly. Do you have the time to keep going to training courses to make sure you're up to date with the latest procedures? Anthony Webb offer 3 services to landlords. Our entry package is our let-only service, where we will find you a tenant, do the reference checks, collect the first month's rent and deposit, and then get them signed up to a Renters' Rights Act compliant tenancy. After that, it'll be over to you to deal with everything. Our middle package is the let and rent collection service. We will find you a suitable tenant, then collect the monthly rent for you. We will also chase any late rent should that occur, therefore removing the confrontation between you and the tenant. Our most comprehensive service and most popular service is fully managed. We will not only find the tenant, we will collect the rent and deal with the day-to-day problems, which always occur. We take this burden away from you so that you have the peace of mind to get on with your day job and have the time for your family responsibilities. With the last two services, you will also be eligible for rent and legal protection. As mentioned before, we put potential tenants through a tough vetting process. Once the tenants have passed their checks, if you are using one of our top two service levels, then you'll be able to take out rent and legal protection. The cost of this is just over £1.30 a day. That's less than half the price of a cup of coffee in a coffee shop nearby. This covers all your rent should the tenant stop paying, all your legal fees should you need to evict, and even covers some of the vacant period after eviction takes place. You will be covered should the worst happen. I'm a letting agent. I've got this protection on all of my rental properties. Using our fully managed service, you will get peace of mind that things are being done correctly. We have many trades registered on our books. In some cases, 2 or 3 people in the same trade. They are all vetted, insured, and because of our long-standing relationship, we get a priority service from them. Once the new Act comes in, getting a rent increase will need to be done more carefully, as Susie mentioned earlier. There will be a strict procedure that we have to follow, but the way this is presented to the tenant will either help or antagonise the situation, which will make all the difference on getting that rent increase. If you use our top two services, my experienced team will know exactly how to handle this and normally get successful results. In the last few years, councils have been introducing landlord licensing. They consult on these schemes, but somehow many landlords just don't know about them. There are 3 kinds of license: selective, additional, and mandatory HMO. Not every property needs a license, but most do. Each kind of license has different requirements and allows for different kinds of tenants. We can check if you need a license, and if you do, we can put in the application for you and be present when the council come to inspect. We know how to handle these people. Over and above licensing, the Renters' Rights Act will create the landlord register that, again, Susie mentioned earlier. A start date for this seems like it's going to be the early part of next year for London and most of the UK. When this comes into force, all landlords will have to be on this register, and once on, you have to register every property onto it. We will be there to help once this all comes in. This is over and above council licensing that I mentioned earlier, so don't get the two confused. As you can see, being a landlord is not simply about having a property, putting a tenant in, and getting paid loads of rent. There's lots of compliance, lots of responsibility, and lots of risk. Why would you risk your investment by not getting a professional to look after it for you? Most people go to a hairdresser to get a haircut. Why, you ask? Because they're trained to do this. Most people go to a doctor for their health problems. Why? Because they're trained to know what to do. Most people go to a mechanic to fix their car. Why? Because the mechanic is trained in fixing cars. We could try and do all these things ourselves, but it would take a lot longer, and most likely we'll make mistakes. Believe me, I remember my self-inflicted COVID haircuts. The same goes for managing your investment properties. Let Anthony Webb take the stress and strain away from you. Reclaim the hours to enjoy for yourself, to spend time with your family and friends, to have time to do your actual job, and to sleep well at night, knowing that you have professionals looking after your investments. Our success speaks for itself. Independent Rightmove stats show that in 2025, Anthony Webb agreed nearly as many lettings as our next 3 closest rivals combined. These stats are just for the immediate area around my office in Palmer's Green. But we do lettings far further afield. We let properties as far in as Islington and Holloway, and as far out as Potters Bar and Cuffley. On the last page, you can see just some of the comments here from landlords and tenants that they've had to say about us in the last year. Very helpful, honest agents, fast responding to a reported issue. Amit communicated well. You'll find Amit in the room. These are some of the reasons that have made us successful and people keep coming back to us. Last year, Anthony Webb won numerous awards. We were voted one of one of the top 500 single office firms in the country in the Best Estate Agents Awards. Plus, we won 3 ESTAS Awards. And these are purely based on reviews by sellers, buyers, landlords, and tenants. After the presentations and the Q&A session, the subject to these mics working, the speakers will be available to answer questions that you may have, and my team. Please feel free to approach any of us. Thank you very much.
Thank you, Tony. Very, very insightful indeed. We have one more speaker for tonight, so please bear with. Our last speaker is Jack Marku, who's going to be speaking about making tax digital. Thank you.
Susie, Tony, thank you very much. Clear at the back. Thank you. Okay, so my name's Jack Marku from GC Accountants in Palmer's Green. Here tonight to speak about making tax digital. So, along with all this that's going on for landlords, we have making tax digital coming in. This starts this April for some landlords. I will go into more detail who it covers. So people do need to be prepared, landlords especially. What is making tax digital? HMRC started this with VAT a few years ago, and they are now bringing it into income tax self-assessment. Accountants have had experience in making tax digital with VAT. So going forward, most accountants do have the knowledge of how to deal with making tax digital for landlords. So what's the change? Quarterly tax updates. So landlords will have to submit quarterly tax returns, not just what we usually do once a year. Digital software. This has to be HMRC approved. So Xero, Sage, Free Agent are the most common used software used. There are other software available. But again, this will come as a cost to the landlord. One thing landlords should be aware of and to plan ahead, have a separate bank account for your rental income and expenses. This will help when making tax digital is implemented. Why? Making tax digital will make use of your bank account. Your bank account will be fed into the software. If you have a separate bank account with just your rental income, expenses, mortgage interest, it's very easy for that feed to go across. If your bank account includes hundreds and hundreds of other transactions, it's going to take a lot more time for the accountant or yourself to go through everything. And the revenue, HMRC, if they require access to the Making Tax Digital software, they will then be able to see each and every single transaction that goes through your bank account. Whereas if there is an inquiry, then all that they will be after to start with is the bank account which your rental income and expenses go out of. So very important. If you haven't done that now, if you do not have a separate bank account, then it's a good time now to get that in line. Okay. So digital record keeping. What exactly does it mean? No more paper. Everything has to be scanned onto the Making Tax Digital software. Now, what does this mean? So, as a landlord, a lot of your expenses will be paid through your bank. You have a job, repair needs to be done to a property. A builder comes to you and says, okay, I can do this job for you, £10,000. He gives you an invoice, you pay the builder through your bank account. No problem. There is a trail. The builder says to you, okay, £10,000, give me £8,000 cash. I'll do it for £8,000 cash. Okay, you say. He gives you an invoice. So he gives you an actual paper invoice, £8,000 cash. At the end of the year, or when you are doing your quarterly returns, you give your accountant the invoice, £8,000. I've paid this builder £8,000 cash, but it hasn't gone through my bank account. The difference now is you have to now prove where that £8,000 has come from. So the source of funds is very important. You have to show you have drawn that £8,000 cash from a bank account. This is where making tax digital, the big change is happening. So this is going to, and the reason the revenue are doing this, it will cause a chain going forward. So you may show that you have drawn £10,000 from your bank account. There may be an inquiry investigation into your return. The revenue will then see Mr. Bloggs, £10,000 paid cash. They will then look at that and think, oh, let's have a look at Mr. Bloggs. Has he declared that amount? So this is where the chain will happen with the revenue, and this is what they will be looking at in the future. And it will be a lot easier going forward for them to be starting inquiries, investigations, because it is digital. They will just be asking for the backup. It will no longer be send bank statements, send receipts, etc., etc. Everything has to be now filed online. All expenses, your income, mortgage statements, etc. And it will be very easy for them just to ask for the information. So we do expect a lot more inquiries, investigations going forward from the Inland Revenue, because it will be so much easier for them to request the information. Now, using agents such as Anthony Webb, who we've worked with for many, many years, quarterly statements are given out from agents such as Anthony Webb, which will help with the quarterly input for making tax digital. These are then reconciled back to your bank accounts, and any other expenses that you as landlords have made are then input into the system. Okay, next slide. Thresholds. So, who is affected? Making Tax Digital is starting in a couple of months, April 2026. So from April 2026, if you have rental income that is above £50,000, you should be in the Making Tax Digital scheme. The rent for £50,000 would have been from the 23-24 tax year. So not the one that's just been filed now, the year before. HMRC have written to most landlords, because they have the figures, and so if you are above the 50,000 threshold, you should have already received a letter from the revenue stating that you should be starting Making Tax Digital from this April. Or if you have an accountant, they should also have advised you. This threshold drops to £30,000 from April 2027 and £20,000 from April 28. the revenue have not yet told us whether from 2029 every single landlord will be under the making tax digital regime. We don't know yet, but we assume that's what's going to happen. One thing to be very careful about, if you are also self-employed, it is a combination of your self-employed income plus your rental income if you reach that 50,000, to reach that 50. So if your self-employment income is 35,000, and we're talking about income now, not profit, for both self-employment and rental. So if your self-employment income is 35,000 and your rental income is 20,000, you are above that 50,000 pound threshold. So it's just something to be aware of for self-employed people. If you have your property under a limited company, these rules do not apply for the time being. So making tax digital does not apply if you have your property under a limited company. Preparation. You have to be prepared, especially, as I stated earlier, with the separate bank account. It will take a bit of doing, but it's something that we at GC Accountants have advised all our clients to do. It is not a legal requirement from the HMRC to have a separate bank account, but it is very advisable to have a separate one. So, practical steps. Record keeping, again, very, very important. I keep going back to this separate bank account. So important to have one and plan ahead. We were talking, our colleagues have been having meetings about making tax digital, I think, for 3, 4, 5 years. It was meant to be brought in a few years ago. It's been delayed. It is coming in now from April. I mean, the last 4 or 5 years, when we first started talking about it, have flown by. So please be prepared, get ready for it, and seek professional advice. I mean, at GC Accountants, professionals, please speak to your own accountants if you have one. You can, of course, if you do not use an accountant, prepare tax returns yourselves, but you do have to make sure you have the correct software to do so. Unfortunately, there is a cost to the software. You may get Sage 0 free for 6 months, 3 months, 6 months, but there will be a cost at some point down the line. Different software have different prices. We're lucky enough as agents for Xero and Sage to get a very much reduced cost for our clients going forward. Timeline, key deadlines. Again, it's knowing when you have to prepare, when you have to start. There will be penalties from HMRC in place. Yes, quick.
I'm really sorry to interrupt.
Yeah.
I know Anthony Webb advised people that there's a council car park. Yes. And it closes at 8 o'clock. Wow. I can't believe that no people have got up to leave. If people at the council car park closes at 8.
Okay, if anybody didn't hear that, and you are parked in the council car park? It shuts in about 3 minutes' time. The council car park. You can grab a tea or coffee or sandwich on the way out.
sorry, that was information. No. I've got my information for the lady that attended this earlier. The lady that was here attending this earlier was parked in the council car park. She said it closed. That's why she left.
Okay.
So that's the information.
Okay, just, I mean, a couple of minutes left and then I'm done as well, so then we can all have our teas, coffee, sandwiches. So just going back to penalties that will be imposed by HMRC. It will be on a points-based system, so if you're late with your first return, it won't be £100 fine, £200 fine. It's like a driving license point system, so if you are late once, twice, 3 times, you will get points for being late. Once you reach a certain level, then there will be penalties for late filing. The revenue have advised us that they will be a little bit more lenient in the first year, but we don't know exactly what that means. You never know with HMRC exactly what that means, but please, 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 just try and make sure if you get it started and done from the beginning, then everything should fall in place after that. Final slide. Again, there's changes happening, I mean, all over the place for landlords, especially when the reform, the new acts, tax changes, it's getting harder and harder and harder. The inland revenue are making it much, much, much tougher for landlords. And as the government said, landlords are not working people. They have said that. So when it came to manifestos saying that they are not going to increase tax for working people, landlords are not part of that. So we've got an increase in taxes coming up for landlords from this April. They've already got rid of the 10% wear and tear allowance a few years ago. As you know, you can only claim a percentage of your mortgage interest now as tax relief. So it is getting tougher and tougher and tougher. You don't want to be getting stuck with more penalties for not complying with this. So please look into it, especially if your income was more than £50,000 from 23-24, because you will have to be registered from this April. Final slide, I think that's us. GC Accountants in Palmer's Green. If anybody does need any help or advice to contact us, please do. We are available 24/7. Yes. Yes, regarding the threshold, so 50,000, if you were above £50,000, if you had rental income of above £50,000 in 23-24, you have to start from April this year. If you were above 50,000 in 24-25, which is just gone, yeah, you're not on the system, so that will be from the following year. It's sort of, there's a bit of a backlog there because they won't know. Yeah.
Guys, questions at the end.
Yeah, if we can. Yeah, I think. Yeah, we're going to have a quick question and answer session. So, thank you, guys. Thank you.
Cheers, mate. Thank you, Jack. All right, we're going to be going to some Q&A questions now. We've got 6 pre-made ones, and then we will be getting someone to come around the audience, so you all will get a chance, okay? Firstly, when reference is made to a rolling-on contract, does this mean you don't need to review the contract unless there are changes, e.g. rent increases, or does it mean something else?
Hello? Is this working?
Yeah.
People hear us? 1 minute.
A lot of technical issues.
Hello? You hear us?
Is that better? No? No.
That's right.
You don't want to hear my Italian voice. Is that better? Yes.
Brilliant.
So, Shay's question about periodic tenancies, I mentioned that for existing tenancies from the 1st of May, you will issue what is known as an information sheet. So, all your existing terms pre the 1st of May will still stand, including rent increases, but not percentages and so on. Okay, so those original terms will still stand, but things like break clauses, no, end date, absolutely not, and basically the tenancy will just roll over.
Thank you very much. Question 2, making tax digital. Who does this apply to in relation to rental income and PAYE?
Regarding PAYE, it has no impact into PAYE doesn't really come into it. So whatever income you receive from PAYE will not affect whether you're under the making tax digital threshold or not. So it's a separate income. As I said earlier, self-employment income that is included in the threshold, but PAYE you could be on either 20,000 or 120,000 pounds a year. Does not make a difference when it comes to MTD.
Thank you. Question 3, from the 1st of May, how can landlords/agents ask for rent increases? Can you still approach tenants and try to come to an agreement, or just serve Section 3 notice without approaching the tenants?
I think you meant by Section 13 notice on that one. The Section 13 notice has been there for many years. Up to now, we negotiate with tenants before it's time for a rent increase. We normally start about 3 months before the end of a fixed term. It's going to be something similar before. We're going to have a negotiation with the tenant before we serve the Section 13 notice to try and get an agreement. If we can't get an agreement, then we'll have to go through the process. But in most cases, I don't see this being a problem. We just have to do it properly. We have to do it in the right manner.
Thank you. There's much talk of a new landlord database. We already belong to the LBE selective licensing scheme. Is there going to be an additional database?
Yes, so that was one of the very last points that I addressed. The database, as I said, will roll out in the Midlands tail end of 2026. Is going to its second testing phase in the next few weeks, and I said earlier that they want landlords' input. That's really important. And then, depending on the success of that pilot, the database will be rolled out across the whole of England. So don't think about Scotland. Think about Scotland, but not in this case. They have their own legislation in relation to landlords, as do Wales and Ireland. We are just focused on England. Shay said about licensing and what happens in London. This database will not replace any of those things. It will be in addition to. So that's really very important to bear in mind.
Thank you. If we advertise a studio flat that's clearly described as suitable for a single person or a couple due to the size and layout, but families with children continue to inquire, how are landlords expected to handle this without breaching anti-discrimination rules when the property is objectively unsuitable under overcrowding or safety standards?
So, I don't know who put that question forward, but that's an excellent question. I didn't address something when I was talking about rental discrimination and the fact that landlords should not enter into a situation where they discriminate against anybody in receipt of benefits or anybody with children. However, there is a new phrase that I'm just going to abbreviate. It's PMLA. So it's a proportionate means of achieving a legitimate aim. So, for example, if it's a studio flat and the applicants have 3 children, aged 2, 6 and 7, then that would definitely be overcrowding and would be a breach. So if there is another reason where you feel that it's in relation to selective licensing schemes, health and safety, not being able to make a reasonable adjustment to the property to allow somebody with children to live there, then you can focus on the PMLA. So you need to look at that really carefully, because there are situations, you know, that question just gives you an example of applicants who think it's okay for a family of 5 to live in a 1-bed flat, and that causes all sorts of problems. So you really need to think about that very carefully.
Excellent. This is the last question from my side, and then we'll have time for 5 to 7 people to answer their questions. Running a little bit over time today, so just trying to be time conscious. With regards to pets and children, do I, as a landlord, no longer have a say in this, even though I wouldn't want to have pets, smokers, or children renting my flat due to the additional property wear and tear?
So the answer is not a yes and not a no. You need to look at each case on merit. You need to look at the application. You need to look at affordability if we're talking about referencing a tenant. As Tony said, the criteria that people have to go through to prove affordability, income, disposable income, and so on is vast. The referencing companies deal with this day in, day out. So that's extremely important to bear in mind. I've already mentioned discrimination against tenants who have children and so on, but you really need to look at what the criteria is to fulfil an applicant in terms of them passing referencing or not. So it's very, very important that you have all the information before you make a decision. So that, I think, you know, the question is understandable, but it's not as easy as saying yes or no. What you must not do is discriminate based on those situations before you've gathered all the information. So that's really, really key.
Thank you very much. Okay, if I can see some hands raised for questions, I'm going to get someone to come around to you guys with the microphone so you can answer it all. Let's start from front to back. You, sir, over here.
Thank you for the speakers for excellent presentation. My first question is for Susan. Under Section 8, you mentioned reason for possessions could be student-led. Can you expand on that, please?
On which type of?
Section
Yes.
Student-led.
Right, okay. So student lets. So some of the grounds are brand new. So we are going from 17 grounds to 18. And we have some mandatory grounds which are brand new. So that's amendment to ground 1, ground 1A, a few in 2, and then they got rid of 3. If you see the list, people will look for 3. They've decided that holiday lets aren't involved in that. And then you've got 4 and 4A. Now 4 is purpose-built student accommodation only. So the type of buildings you see predominantly in university towns and cities, usually maybe funded by the university, a pension fund and investors and so on. That ground is specifically for that type of property. It's 4A that you need to look at very carefully because it's got time frames attached to it. You need to pre-serve that ground. It's for the type of property that is an HMO, 5 students, everybody has to be a student, and it's specifically for students and not a combination of anything else. So look at the timing going into 2026, 2027, and making sure that you sit in line with those timeframes. But that is available to you.
My second question is I thought the £50,000 threshold applies outside self-income. In another presentation, that's what I was told, that your personal income is outside the 50,000 threshold.
Sorry, you mean if other income is? Yeah, other income has nothing to do with making tax digital for landlords. So
Just self-employed income.
unless you're self-employed. Yeah? So if you're self-employed, then it is a accumulation of your self-employed and your rental income. But any other income that you receive has nothing to do with making tax digital for landlords. So if your rental income is above £50,000 and then 30 and then 20, you are eligible to be for making tax digital.
For example, pension income, does it come into it?
No, pension income does not come into it whatsoever. So what happens is the 4 quarterly returns that are done are just for your rental income. It is just sorry, it's one thing I forgot to mention earlier. Payments of tax do not change, so you do not have to pay the tax quarterly. So the tax payments remain the same January, July. But no, so all that gets submitted in the quarterly returns is your rental income. So you do 4 returns a year, and then the final return at the end of the year is the return that everybody does now, which includes the total of the rents and expenses, plus any other income you receive, pensions, employment income, etc. So it's 5 returns in the year that you have to do.
Yeah, you sir, right behind. Or madam, sorry.
Yeah, I guess this one's for Tony. I have a concern here regarding full management, and having full faith and trust in the agent actually doing what they need to do to make sure we're compliant. So I guess, I don't know, I would have to look at contracts between landlords and agents now and make sure that, they're fitted. That concerns me because who's liable in this case if we're faced with a fine?
Well, contracts are there. We've always had contracts between our landlords and our tenants. Up to now, we've been running for 26 years. We haven't had one case of an argument between us and any other landlords. We manage a couple of 100 properties, all fairly local. We pride ourselves on doing a good job. But yes.
Something's missed. Who would be liable? I mean, if there was a big fine of £7,000 like this, an example, I mean, how
If it's negligence from the agent, then it's going to be us, and we're insured for that. Yeah. Yeah.
Absolutely. We'll do 2 more questions.
Sorry, can I just add to that? I think you're right to think about those things, but it's the burden of proof. So those of you that have a good understanding of contract law, is it the agent's fault? Is it the landlord's fault? I deal with this kind of thing every day. Our agents, the ones that we work with, are belts and braces. That's what you're looking for. So it's really important that you do read your contracts. Contracts are changing, so that's really key. But if you put your faith in your agent, and I'm not necessarily talking about anyone here, but if you're using agents that are away from here, do your due diligence on the agent. It's really, really important, because you're right, who's going to take responsibility? If it's your mistake on a let only, where everything up to passing management over has been done really well by the agent, and then you take over and there's a risk, then it sits with you. Under management, they look at both of you. But if you've got a managed property, they will be looking very closely at the agent. So that's really key.
Okay, hands please. We've got time for 2 more, and then of course at the end you'll be able to speak to everyone one-on-one. Let's do someone from this side. This gentleman over here, please.
He's a really good MC.
This is for Jack. I have my bank accounts are with the old school. We have absolutely everything down through here. What do you suggest based on the digital that we have to do our accounts? What's the best way forward? Because if we have to declare that account, those statements, there's hundreds of things on there that HMRC probably would question you.
Yeah, I mean, this is the one thing that, look, we've been advising clients about this for a while now. I mean, we've always said to clients, even if they're self-employed, to have a separate bank account, and now especially more for landlords. set up a separate bank account. I know it may be a bit difficult to start with, but set up a separate bank account for your rental income and expenses and your mortgage, if you have mortgage payments to go through. Because not just if there's an inquiry investigation, but it will ease the Making Tax Digital process, whether you're doing it, whether your accountant's doing it. It will be a lot, and it will cost you less, because it will mean less time that the accountant has to spend on the quarterly return. So it may be a bit difficult to start with, but speak to your bank. Banks are aware of this, and just set up a separate bank account as soon as possible.
Thank you, Jack. Thank you, sir. We've got time for one more. You, madam, over there, please. A little bit closer, please. Thank you.
If I want a tenant who earns 2.5 times the amount of the rent and has got a clean credit history so that I can get a rent guarantee, am I being discriminated?
Do you want to take that? Referencing. Oh.
You say that one.
This is one of the issues that's come up in terms of referencing. So the first thing is affordability. The second thing is that referencing companies are looking very closely at their policies. Now, I know the big referencing companies are looking at whether they can offer rent and legal protection to someone who may be short on affordability and have some issues in the background. But no, you wouldn't be discriminating. The one thing I will say, I mean, I know this is very difficult. I'm actually not allowed to talk about insurance, so I can't go into huge amounts of detail because I'm not FCA accredited. So, yeah.
Thank you very much, guys. As I said, the panel will be at the back with the rest of the Anthony Webb team. You'll also find refreshments and sandwiches. Thank you. Good night.